Hi, everyone, and welcome to Raw Law. We are here. This is live today. I'm Arkady Frekhtman, a New York City personal injury trial attorney. And this episode is all about you, the viewer, where you could log in live and ask questions, and we can give you feedback, answer your questions, have a chat, and able to help out. And I apologize for coming in a little bit late. I think originally it was scheduled for 4:15. But what happened was the live link didn't work because it was for like mobile phones only. And I was doing it from my office from the desktop. So that's why I had to create a new live. But welcome, everyone. Thank you so much. Let me know who is here and who has a question. And if there's nobody in the room yet, because it's a brand new stream. I don't know if people might be in the other room. I saw a few comments in the other room. So people probably don't know about it. So what I'll do is I'll start off by maybe asking some stuff on the channel. I'll go to our channel and I'll see what questions we have on our channel, and I could start off by answering some of those questions. So let's see. I'll go to YouTube Studio, and actually no, wait. Before we do that, I think somebody has a question. Anjanya says, I'm here and have a question. Okay, yeah, let's go. Anjanya, how are you? Great to see you. Absolutely, go ahead, ask the question. I'm happy to answer. I'm happy to help. That's what it's all about. We're trying to help serious injury victims and families, give as much to them as we can so they can do better in their case, so they can get full justice, maximum compensation. Yeah, I'll make sure it's in live chat mode. So while Anjanya is writing his or her question, let me see what we have here in the comments section on the channel. In the comments section in the channel. I don't know. I don't see too much in the channel. A lot of the comments are about some of the shorts and stuff like that, but that's not really a question. Let me see. Harden has a question. Hey, why does my attorney need to talk to my dad and family? What questions he may ask? I mean, I don't know, like what kind of, I have to know what kind of case you have. First of all, what's the case about? Why does your attorney want to talk to your dad and family? I mean, there could be many reasons. I mean, one of the reasons I like to talk to family members is because, if I'm presenting a case and I'm trying to prove that a client has been seriously injured, then I want to talk to their family because they'll tell me things, right? Like what they can't do. So that could be more of like a discovery call. Like I even go to the client's house, I find out all about them. So I'll talk to their dad, to their mom, to their friends, family, things like that. But, I don't know why your attorney, I mean, the best person to ask would be your attorney, because if he has a reason to want to talk to them, he could tell you. Obviously, you're the client, right? It sounds like you're the client. So, if you don't know, you could just ask him and he'll let you know. Okay, and then here's the question from Anjanya. I'm hitting roadblocks and justice as the other party is lying about the scenario of events that happened. He lied and his insurance believes him. What can I do? I see. Well, again, I need a little bit more information. The best thing to do is maybe tell me a little bit about the facts. You don't have to go into great detail, just like one or two sentences, like what's the case about, what happened. Just like imagine I'm watching it on Netflix, right? I want to be able to see it. I want to be able to see what happened, and then tell me about your injuries. Tell me what city you're in. That way I could give you some feedback or some constructive criticism, something constructive feedback, maybe some questions you could ask your lawyer, some things you can do. I mean, if you're just saying somebody lied, right? What could I, I can't really tell you. I mean, people lie. Yeah, that happens. I mean, what could I tell you with that? You know, you got to give me something, kind of like that movie, help me help you. You know, you got to give me something so I could give you something back. If you just tell me, hey, somebody lied. Okay, somebody did. What could I can't really give you anything back. So, you know, give me a little bit more information. Okay, and then Harden says it's a truck accident case. Yeah, well, that's a good case. So he wants to talk to your dad, but I don't know, like, are you a child? Are you, you know, maybe if you're a child, then the dad is your, you know, he needs to talk to the dad or the mom because you're a child. If you're under 18, if you're an adult and he wants to talk to your dad, it could be because, like I said, because your dad may know about how the truck accident changed your life, about how your life was before, how your life is now, and you know how it's impacted you. So that would be a damages evaluation, and it would help prove damages. Maybe that's why. But I would just be guessing. The best person to ask would be the lawyer. You know, if you're curious. Okay, Anjanya says, I was rear-ended. Now he tells them I cut in front of him and I was stationary. So he basically lied. Yeah, so that happens a lot. I mean, that's very common. So you were rear-ended, but he's saying, like, you know, you cut in front of him. So the way to avoid that would be, I mean, obviously your testimony is one. You just say that didn't happen. I didn't cut in front of anybody. I was stopped. I was stopped for whatever number of seconds, 5 seconds. That's an appreciable period of time. I was stopped for 5 entire seconds. And then he rear-ended me. He crashed into my rear. And look at the damage. It's straight to my rear. If I had cut over, right, wouldn't the damage be to the corner panel? But it's not in the corner panel. It's in the rear. You know, show them the property damage. The other thing you can do is have your lawyer request the electronic data recorder, the event data recorder. If it's like a truck that hit you, or even if it's a car, all cars have these EDRs, event data recorders. They capture a lot of information, such as the speed of the vehicle right before impact and even at impact, and the speed of the vehicle even up to like 30 seconds, a minute before impact. So if you cut him off, that would mean he's driving at, let's say, a particular speed, and then you cut him off. Maybe he hit the brakes and then he hit you. So all that data that you can get, all those analytics from the EDR, the event data recorder, which is also known as a black box. They have them in airplanes, and the NTSB, the National Transportation Safety Board, actually goes and looks at that. And then it takes them like a year, but then they figure out, why did the airplane crash? So the trucks have them too, cars have them. So you can look at that, and then that data will help prove that he's lying. And then if you can prove that he's lying with data, right? That's objective data. Now he looks really bad, right? Because he's not just telling his version of what he thinks actually happened, but he's purposefully lying. So if you get him in that, you could almost like sue for punitive damages and get more. And the jury will get so mad. They'll say, what is this guy doing? Not only did he hit this poor guy, hurt him, but now he's purposely lying to try to avoid, you know, getting the injury victim getting justice. So then your verdict is going to go way up, you know. So absolutely, yeah, do that. Get the event data recorder. Maybe there's a dash cam footage. You could try to get that. Just get whatever evidence is available. But I wouldn't worry about that. You know, if you want, just text me 347-566-9595. I'm happy to jump on a call, and you know, that way we could flesh out all of the details. Maybe I can give you even more information. You know, more value that, you know, I don't know what city you're in. I don't know what your injury is, but yeah, absolutely. Absolutely. Oh, you're saying a 20-year-old SUV? I mean, it's possible. They've had event data recorders even like going back, but you'd have to check if it exists. You'd have to request it in discovery. And then there are some experts that's what they do, is when you give them the data, they're able to take the data and then review the data and then pull out a report. It might cost a little bit of money. You know, I'm not sure exactly how much it costs. It might cost like a few $100, but I think that some of these experts, that's what they do, and they do a great job. Like we had it done recently in a case, usually with trucks, but I don't know if your case is with a truck. Oh, you say SUV, so it could be, yeah. And then Harden says, I live with my dad. Oh yeah, so if you live with your dad, that's probably why, that he wants to find out a little bit about what your dad knows, right? Because you never want the injury victim to be the only voice, right? Because let's say a person is injured, right? And that person is going to say, oh, I'm so hurt. My arm hurts and my leg hurts and my head hurts and my back hurts and everything just hurts. And then the person just becomes like a whiner and a complainer, and it's not very powerful. But if you have the person just say, look, I try to do things, right? You want to always tell the try story or the hope story. I try to do things. I try to play sports. I try to walk. I try to run. I try to do whatever. But then you have other people say, yeah, he tries, but he's really not. He used to be X. He used to be like lifting weights and running and powerful. And now he's Y. He's not X anymore. He's not who he was. Now he's a different person, a different man, a different woman. Now he or she is just like a shadow of his former self. He's not able to run. He's not able to walk. He's a burden. He's really like not even able to buy groceries or do simple things. You know, that's powerful. And you get it from other people. I mean, you get it from like neighbors, coworkers, could be your father, you know, friends. But like the more you have of those witnesses, and they don't have to be on the witness stand for very long. They could be on the witness stand for even like 5 minutes. But you have like 10 of those witnesses. Wait a minute. Are you telling all 10 of these people are all lying? You know, they're all telling different parts of you. Somebody talking about how you were at work. Someone else is talking about how you are, you know, at home. Someone else is talking about like, you know, sports that you play, maybe in a sport league, you play football or basketball or tennis or whatever it is, golf. You know, all these different people from all different parts of your life are all lying. Like, you know, it's a big conspiracy just to, you can get like a payday in this one case. You know, it's, come on, it's impossible, right? So it makes their argument, because their number one argument is to say, oh, you're a liar, a cheater, and a fraud. You're not really hurt. It's all degenerative, right? It's all from living your life. And you're just coming into court and you want to win the lawsuit lottery, right? You want to make a payday on a false case that you orchestrated. That's the whole mantra. Like, you know, it's like they have this playbook. That's their playbook, you know. If they had a playbook, like that's their playbook. They always have the same playbook. So it's kind of easy to beat them because you know their playbook. It's always the same. So that's the way that's one of the ways to beat them. Okay, let's see. What other questions do we have? Okay, Nature Boy says, what is the longest a case can settle or go to trial? My case has been going on for 5 years and 3 months. Well, I mean, yeah, that's a long time. I mean, 5 years and 3 months, but it depends on what stage the case is in now. You know, is the case, for example, already on the trial calendar and everything is done? And then has either your lawyer or someone else been able to tell you how much longer you have to wait? Sometimes a lawyer could say, okay, your case is on the trial calendar. We have a pretrial conference in October. So if it doesn't settle at that pretrial conference at that October date, the judge is going to give us a final trial date, probably for December or maybe January. And that's it. That's like when, you know, the case is going to get resolved. So try to find that out. Give them a call, speak with them, maybe go to their office. If they, you know, if they're not answering the phone or speaking to you on a phone consult or doing like a Zoom video like this, like one of these videos, if they're not doing any of that, maybe try to go to their office and see them in person, make an appointment. But yeah, you should really find out from them because it's hard, you know, to say. But yeah, I mean, generally 5 years is a long time. But some cases, you know, I don't know about your case either. Some cases take 5 years because they're complicated, you know, and or because the courts are slow. The courts are just slow. Like everything's done. The case is on the calendar. I'm ready to try the case today. I'm ready to try the case tomorrow. But they're not going to give me a trial date today or tomorrow. They make me wait another year just because the courts aren't ready. Because they have other cases. They're inefficient there. It's a big bureaucracy, you know. So I don't know if you're in New York. New York has been like slow lately. So yeah, it just depends. And then 83. Oh no, let me see. Anjaya says, how can you fight a letter of denial of liability by the opposing party? Well, just file a lawsuit. You know, make sure you have a trial lawyer, first of all. If you don't have a trial lawyer, if you have, let's say, somebody who's just a, you know, one of these like billboard lawyers or just like one of these claims lawyers who just gets a lot of cases and just settles them on the phone. I mean, you can almost do that yourself. You got to make sure you have a real trial lawyer who has a history of going to court and taking jury verdicts, and that those jury verdicts are in the same amount that you want to get in your case, right? Sometimes people have a lawyer, they think I have a trial lawyer. Okay, but you go to like a verdict search, you go to the public court database, and you could see like what results they've gotten in the past. And if the results they've gotten are like, you know, $5,000, well, you don't want $5,000. You don't want that guy. You want the guy who gets $5 million, right? So that's basically all it is. And you don't have to fight the letter. I mean, they send you a letter. You could send them a letter. What's a letter? A letter is nothing. It's a piece of paper. Just throw it in the garbage. That's how you fight it. File a lawsuit, take a jury verdict. That's how you fight it. Yeah, so. And he says he's having trouble finding a good trial lawyer. Well, why? Have the trial lawyers explained? Have you tried speaking to a trial lawyer? Has a trial lawyer explained like why, they're not taking your case if you tried to find one and they rejected it? So I guess that's the issue. You can usually answer any of these questions, but you just have to do a little bit of a deeper dive. It's never like, it's never like the first question. It's always like you need to ask a few more questions. Like I think they have this thing called the 5 whys. If something is a certain way, well, why? And why is that? And why is that? And when you get to the 5th why, then you can figure it out. It takes a little digging, but you can definitely do it. Okay, let's see. I think that was actually like Samsung, one of those Japanese CEOs of one of those companies that came up with that, the 5 whys. You could probably Google it. I think it really works. It's a smart thing. Okay, let me see. So somebody else is asking, 83, the Casanova is asking, mediation is coming up, what to expect? Yeah, well, I did a video recently about, actually today, I shot a video earlier today. It's a recorded video, so it'll come out probably in a few weeks, all about mediation. But the thing with mediation is I wouldn't do a mediation. I wouldn't agree to it. I wouldn't show up unless you have a good faith offer. So for example, if you're looking for $1 million, okay, if they give you a good faith offer, let's say they start off at 275, 300,000, and you already have that offer, sure, go to the mediation, because you know what's going to happen? You're at 300 now, and at the mediation, they'll go to 500, or they'll go to 700, or maybe they'll go to the full million, right? And the case you can come down a bit, they'll come up a bit, and it'll settle right in the middle somewhere. But if you don't have any offer, what they're going to do is, a lot of the time, I'm not saying they're going to do this like 100%, but what they love to do is they love to use the mediation as a tool to like disillusion the relationship between the client and the lawyer and just kind of breed discontent. And what I mean by that is, they're going to agree to go to a mediation. So usually you get contacted by the mediation company like NAM or JAMS or whoever it is, right? One of these companies. And of course, the company wants you to come because they're going to bill you like $500 an hour for the neutral's fee. The neutral is the judge, right? The judge's fee. They're going to charge you like $500-600 an hour. For that, they're going to charge you a mediation fee, the conference room fee, whatever. They're going to charge you like $2,000. So of course they want you to come, But this is what happens. So you show up and you think your case is worth $1 million. So you do all this work and you prepare a mediation memorandum of like 50 pages. And you do research, you go through all your experts, liability, damages. You show up and you say, okay, here's my presentation. It's $1 million case. And then they say, no, it's not. Oh, it's degenerative, or it's not caused by this, or we don't like it for this and that reason. And it's usually some, phony baloney reason. And they say, oh, we'll give you like, our starting offer is 20,000. And all we have on this is a number under 100. And then, the client turns to the lawyer and goes, why'd you bring me here? Well, what is this? And then the lawyer's like, well, I don't know. They agreed to mediation. I thought we were going to have a good faith negotiation, and all it does is make you upset, make you think that your case isn't worth much. Or the lawyer, if they're not a trial lawyer, are afraid. It's like, what am I going to do now? I'm not going to go to trial. I don't go to trial. I'm not a trial lawyer. I got to take it. So then the lawyer starts, telling the client to take this lowball number. The client doesn't know what to do. They get upset. And the whole thing just like, it's not a good, and the insurance company knows it, right? This is their like plan from day one. This is their, it's kind of like, this is what they wanted. They want to put you into this trap. So don't go to a mediation unless you have a good faith offer. Because look, what's so magical about the actual mediation? Like when you step foot in this room with this judge who doesn't have a power to order anything, right? The judge is just like a counselor, like a neutral, a mediator, right? What is mediation? It's facilitation. They try to get the two sides to agree on a number. They don't really, it could be a small number, it could be a medium number, it could be a large number, but they just try to get the two sides to agree and to settle the case. So it's basically like a settlement facilitator. They want to make settlement easier for you, right? For all the parties. And they want to get more business from the defense, from the insurance companies, defense law firms, and from the plaintiffs, right? So they're not really like, on your side, and they're not issuing an order. Like an arbitration is different because they issue an order. They say, this case is worth $50,000. That's it. That's the arbitration decision, and you got to stick to that. But a mediation is just a chance to settle. So I wouldn't do that unless, like I said, unless they give you a good faith offer, because you don't want to show up there and get disheartened and get upset, and then it doesn't lead to anything. And all it does is help them, and they know it. So they use that as a tool to screw over injury victims. Okay, and then Bag Boy says, I would like to switch law firms because my lawyer doesn't want to go to trial, but they tell me I have a strong case. They want me to settle within the policy limits, but I had a spine fusion. Yeah, I mean, you should speak to somebody else. I mean, if the policy limits, first of all, you got to make sure that you know the policy limits, like find out the policy limits, the primary as well as the excess or umbrella. A lot of the times, like lawyers, like I'm working on a case right now, a lawyer says, oh, it's $1 million policy, and they couldn't even get the million. And then I find out, yeah, it's $1 million policy, but there's also a 25 million excess. So now I have the million already, and I'm trying to get into the excess and get him some more money from the excess. You see, so it's just a different way to approach the case. So you don't know until they tell you, until you serve the discovery requests for production, and until they actually respond in a meaningful, substantive way, and they review them. And now, like in New York, as well as pretty much in every state, they have to tell you. You don't even really have to ask. They have to tell you the primary and the excess. And if they say they don't know about the excess, or it's not known at this time, that's all phony baloney. Just throw that out the window. They have to give you an affidavit of search. They have to give you a broker's affidavit, because the broker is the person who procures or creates the policy, right? They wrote the policy. They found the policy. So they have to confirm that there's not really any excess. You want to find that out as a matter of fact, as a matter of certainty. Don't let them say it's not known at this time. What does that even mean? Not known at this time? Was it known at an earlier time, like yesterday? Is it going to be known tomorrow? It's all phony baloney. It's like, it just upsets me, because they do. It's almost like a 3-card Monte game. They try to play so they could like not pay the injury victim and save their money, but they're like making $80 billion a year, and they're still playing this 3-card Monte game with you. It's just sad, these guys. Okay, and then Carved Life says, if a doctor neglected to do an MRI for epilepsy, then had a VNS implant installed for seizures, and there were tumors in the brain the whole time, is he liable? Oh, you mean like a medical malpractice? Well, to determine that, you would need to get all the medical records, have somebody review it, like a medical malpractice attorney in that city where it happened, where you live. And then it could be, I'm not too familiar with that. I'd have to research that. And the way it works at least in New York, is you're not even allowed as a lawyer to file a medical malpractice case unless you sign an affidavit swearing to the fact that you already had all the medical records reviewed by a medical expert, a doctor, and then that doctor has told you that the case has merit, meaning they reviewed the case and the case is a strong case and there is a mistake, and that the mistake caused the injury. Then you can file the case in court. So you're not even supposed to file the case, unless like maybe if the statute is coming up, that's an exception, the statute of limitations, then you can file it. But otherwise, you can't even file a case. So, so that's just the rule. Renee says, forgot to mention I had neck surgery, C4, C5, and C6. Oh yeah, I'm sorry to hear that. That's pretty serious. Yeah, neck surgery is pretty serious. But I don't know, was there an earlier comment from Renee? I think that's the first comment. Or maybe they changed their username. I'm not sure. I don't see an earlier comment. Oh, and she says, can you do videos on big box clubs, please? Oh, like big box stores, like a Costco or a Walmart? Yeah, sure. I could do some videos on that. Yeah, absolutely. Yeah, I've handled some cases against them. Okay. Air Congo says, Mr. Arkady, can you testify if you are confused? I mean, faculty issue. Faculty issue? I'm not sure what that means. What do you mean confused? Well, I mean, the law basically says you can testify if you're an adult unless you have, let's say, a traumatic brain injury, right? And then you're incapacitated. If you're incapacitated legally, that means you're incapable of making legal decisions. Then perhaps you need somebody appointed, like an administrator or an administrator. And then the administrator, like a guardian ad litem, and then that person will testify for you because you're not capable of testifying. Sometimes little children, they don't testify either, right? Because they're little children. they don't understand like right from wrong, they're not able to. But usually you can testify as long as you're okay. And then Gatry says, "Hi, Mr. Frekhtman. How are you doing, sir? I had my surgery done and I'm healing." Oh, hi, how are you? I'm glad to hear that. That's awesome. I'm glad to hear. I hope you're feeling better. Yeah, text me. We could chat. We could chat about it. I'm happy to help. Yeah, she's a really nice lady. Yeah, absolutely. And then Hardin says, "Is it best to settle for the policy limits, 750,000, or just go to trial? The money will not bring my happiness back. I've been suffering every day. The life I had before is destroyed. I just isolate myself." Oh yeah, I'm sorry to hear that. I mean, it's hard for me to say what's best. It depends on whether or not there's excess and umbrella beyond the policy limits, whether that's been confirmed, like if there isn't. And look, if that's all they have, and then you've explored every other avenue, right? Whether like sometimes there's so you can go after your own policy on uninsured motorist. But if there's no other available insurance, then that's the only option. If that's the only option, then that's what you have to do. You just have to take it because that's the only option. So it just depends on all the facts and circumstances. So basically, yeah. So it's hard for me to say otherwise, but that's usually how it works. Okay, and then what other questions do we have? Let me see. Oh, here's a question from Anjanya again. "Is it wrong to reject a treatment for your injury when there is a risk factor in the treatment that would make you 10 times worse off?" I mean, it's up to you. That's up to really you and your doctor. It's not really wrong or right. It's just whatever you think is going to be helpful for you. I wouldn't do any type of treatment just for a case, right? The case is kind of like by itself, but the treatment is more like your life and what to make you better. So if you feel like it's going to make you better, it's going to work, and doctors recommend it, do it. If you feel like, hey, there's a risk factor, it can make me 10 times worse, of course, don't do it, or maybe get a second opinion. So that's, yeah, definitely get that checked out. And then Brandy says, "I was rear-ended by an 18-wheeler in Texas, and the 18-wheeler said I switched lanes, avoiding hitting the other vehicle that had spinned out on the highway. But it's not true. I was already in front of him." Oh, okay, right. So that's kind of similar to the case we just talked about. So yeah, if they're saying that you cut in front of the car, they're trying to put the blame on you. But if that's not what happened, just get whatever evidence is available. Dash cam video from your car, EDR, the event data recorder for your car, for the other car, especially if the other car is a truck, an 18-wheeler. An 18-wheeler will always have an EDR, an electronic data module. Make sure you have a truck accident attorney. That's really important because a truck accident attorney is going to know that particular truck, and usually they'll go to the scene. They'll have a truck expert, like a safety expert, examine the truck. Some of these trucks have software. Some of the software is like automatic braking or other things that you can get, and you could obtain all that information, and you could use that to support or bolster your case to prove that you were not at fault and that they were at fault, that this is not what happened. And like I said in the other example, if you can then prove that this guy is lying on purpose, then your case value goes up, because not only did he injure an innocent victim, but now he's lying about it, right? Purposefully. So that's kind of like malicious intent. And then the juries get really mad at that, and they allow for big verdicts on those kind of cases. If you have a serious injury, it could be a good case. And then the hire says, "Is it true that the insurance companies don't have to disclose how much reserves they have for a case?" Well, you could ask them what reserves they have. They may tell you. You could tell them what reserves to set. Like I tell them in my letters, when I write a letter, like a settlement opportunity letter, and if I think a case is worth, I tell them, okay, you could settle the case for $1 million. You have 30 days, but if you're not, then after the 30 days, it won't be $1 million anymore. It'll be 3, and set reserves of 5. Because at trial, it might not even be 3 anymore. It's just going to keep going up. Just like they you want to go down, right? They want to say, "Oh, you're asking for $1 million. That's so much. That's so much. All we have is 100,000." So they want you to get off your million and ask them for 750. That's still going to be too much. 500. That's still going to be too much. until you get down to where they're willing to pay, like maybe, 200. Okay, now it's closer, but it's still much. But how about 100? We could maybe try to get to 100. Okay, 100. Oh no, but we can't get you to 100. We can get close. That's 6 figures. It's not a 6-figure case. We could get you maybe 85. And see what they did? They just drag you down from $1 million down to 85. But so you do the same thing, but you do it the other way. You go up. You go stair step up, up. And that way they have to control their risk. They get scared, and then they end up paying you what you want. But yeah, I don't know if they have to tell you their reserves. Honestly, I don't know that. They might not, but it doesn't matter. The reserves are just like the outermost limit that they set on the file in order to, protect themselves. Sometimes they get it wrong. They could set reserves of 5 million, but then you go to court and you get 15 million. They still have to pay it. It doesn't really matter what they set as their reserves. That's like an internal thing. But like I said, the best thing to do is tell them what to set, and then they know you mean business. Okay, and then SCB says, how long can the defense lawyers delay providing discovery that my lawyers have demanded? Well, usually they can't really delay that. They're supposed to provide that immediately, but if they do delay, then your attorney should do something about it. Your attorney should file a motion to strike their answer, a motion to compel the discovery, a motion for sanctions. That's all litigation obstruction, basically. So what they do is they give you boilerplate objections like, oh, it's cumbersome, it's burdensome, it's whatever, I don't know, so we don't have it, it's too hard for us to look for it. But meanwhile, you can overcome all of that. Actually, I have a book on all about that. Let me see. Grab it. It's a little bit over here. Look, right here. Litigation Obstruction, Breaking Through. This is a good book from AAJ, all about, and as you say, I was reading it already. I started reading. It's like a long book. It's like 700 pages, all about obstruction. Because there's many ways they try to do obstruction. What they do is they, number one, they delay, or, they don't respond to your discovery and they just say, oh, that's an objection. Okay, it's an objection, but like, where's the actual meaningful discovery? So now the courts have these new rules where they're getting a little bit fed up with that, and they're starting to do away with that, and they're starting to penalize them. But you just have to keep fighting. Like, for example, in federal court, it's much more strict. If they don't give you discovery, you write to the judge, you file a motion, they're going to get their answer stricken, or there are going to be sanctions. In state court, like in New York, first time you make a motion, judge is going to, depending on what county you're in, judge might not do anything. Second time, they might get you an order. But third time, they might think about starting to preclude or strike. Yeah, it's a process. Unfortunately, it's not so efficient. It's a little slow. And and a lot of the times, there's not enough teeth. There's not enough, response to this. Yeah. And so what other questions do we have? And Janya says, oh yeah, to Brandy, that also happened to him. It's frustrating. And Adrian says, how can I reach you? Can I text you later? Yeah, absolutely. Just text me 347-566-9595. Text me. Yeah, when you text me, just let me know the facts of your case. Let me know your injuries, your city, and maybe the date of the injury, just so I know when it happened. And then we can jump on a call. It's always free, confidential, and we do a consultation, just like a chat. We can answer your questions if you have any questions, just like you would over with a friend over like a coffee. But like, we're knowledgeable. We could tell you, hey, these are the possibilities. This is what you can do. This is what you should not do or can't do. Give you all your information so you can make an informed decision and do the best thing for your case. Let me see. Yeah, so I think I've answered all the questions. I don't know if there's any other questions. All right, so I guess we could call it a little bit early. Unless someone else has any other questions, feel free to drop them in the chat. If not, then we can call it for today. It's summertime, so maybe people are busy or relaxing on the beach somewhere. We're getting a little bit, not that many questions. Oh, and Janya says, how do you get durable medical equipment when PIP is run out? So when PIP is run out, I mean, if it's run out, you can't really do much. You can try to use your health insurance. If you have health insurance, you can try to do it on lien. A lien just means that it's like a letter of protection. It's free. Now the doctor will give you like equipment or treat you for free, but then later when the case settles, you have to pay them back a piece of the pie on a lien. And I think I missed one comment. Lynn says, I was confident you'd message me back. I'm not sure what that's about. I don't think I got any messages. Maybe there was a message I failed to return. My settlement will pay law firm bills. I don't know what that means. But yeah, feel free to message me. If I don't message you back, you could just message me again. Just remind me. I try to message everybody back or set up appointments and do phone consults with everybody. But maybe sometimes, I'll get a little busy. I've been doing some depositions. I just had a trial in July actually in June, in mid-June, we had the trial. Now we have a bunch of depositions and other stuff, and, paperwork and motions and summary judgment and letters. I'm doing a lot of settlement letters, so that's good. Settle some cases. So absolutely. So if I missed it, I apologize, but I'll get back to you. Just text me again and we can do a call. In fact, I'm supposed to do a call right now. I'm going to probably do a call in like the next 5 minutes. I have to call somebody. Okay, so Anjanya says, okay, we did that one. Renee says, thanks for your videos. I enjoy watching. This is my first live with you, watching from Louisiana. Oh, thank you so much. I really appreciate that. Yeah, Louisiana is beautiful. I've been to New Orleans before. I want to go again. I haven't been in a while, though. I think back when I was in college, I went to law school at University of Texas at Austin. So from Austin, Texas, you could drive. It's like, 5 hours, and you get to New Orleans. I've been there. It's beautiful. And Carve Life says, if the doctor has retired, is his insurance company still liable? Yeah, as long as he had insurance on the date of the injury, when it happened, the date of the mistake, you should be fine. As long as it's the insurance that he had then. Whatever he does later, retires, or it doesn't matter. So Bag Boys, can I send you a copy of my demand letter so you could go over it to see if it's legit? Yeah, sure. Just email it to me. You could email it to contact. Oh, hey, I'll drop it in the chat. Contact at 866attorneylaw.com email. Yeah, absolutely. And then it takes a long time to settle, and some durable equipment isn't covered by Medicare. Thank you very much for your time. Yeah, unfortunately, sometimes it's just not covered. I mean, unfortunately. Gatry says insurance doesn't cover medical equipment. I'm learning the hard way. And Joe Dirt says, my wife thinks we look alike. Oh, nice. Okay, awesome. And Harden says, thank you for everything. You're a hero to the people who are confused and need insight, and we can all put our trust in you. Oh, thank you so much. I really appreciate that. That's a really sweet, nice thing to say. I try to get better every day, learn as much as I can, read, study. Like I got this book, 800-page book. It's big. Litigation obstruction. We got to break through. I like the cover art too. See, he's breaking through. You got to break through the walls, get justice. Okay, everyone, have a great day. Thank you. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping injury victims and families, and we will talk to you very soon. Have a great night. Okay, bye-bye.